Today we are going to see introductory part of Indian Evidence Act. भारतीय साक्ष्य अधिनियम 1872 ये जो कानून है, ये कानून में जो सेक्शंस है जिनका काम कोर्ट्स ऑफ लॉ में चलता है, उसके बारे में जानकारी इंडियन एविडेंस एक्ट 1872 में दी गई है. इंडियन एविडेंस एक्ट 1872, this is a procedural law. In this act there are 167 sections. These sections are divided into 11 different chapters. This is a lex Khoury law. Now, Indian Evidence Act, this explains the trial procedures which are taking place in the courts of law. There are different sections. The total number of sections which are there in Indian Evidence Act are 167. This act came into force on 1st September 1872. Now, what is section 90? Section 90 explains about ancient document. Now, what is ancient document? Suppose there is a document which is produced inside the courts of law. That document is 30 years old or more than 30 years old. At that time, that पर्टिकुलर डॉक्यूमेंट इज टर्म एज एंशियंट डॉक्यूमेंट. एखादा कागज जो 30 साल पहले का है और वो कोर्ट्स ऑफ लॉ में प्रोड्यूस किए वाला है, एनी डॉक्यूमेंट विच इज मोर देन 30 इयर्स ओल्ड, इट इज टर्म एज एंशियंट डॉक्यूमेंट. दे आर प्रिज्यूम्ड टू बी ट्रू अकॉर्डिंग टू द कोर्ट्स ऑफ लॉ. सो दीज आर द एंशियंट डॉक्यूमेंट्स. They are presumed to be true. Now, Indian Evidence Act 1872 explains us about admissions. Section 17 of the Indian Evidence Act explains and defines what is admission. There are different types of the admissions. Admission, kabuli. There are different types of the admissions. They may be formal admissions, they may be informal admissions, they may be judicial admissions, they may be extrajudicial admissions. Now, in Indian Evidence Act 1872, there is also a definition of confession. Now, there may be different type of the evidences inside the courts of law, different type of the witnesses inside the courts of law. But the oral evidence which is given in courts, that must be direct. Section 60 of the Indian Evidence Act explains about oral evidence, and section 60 of the Indian Evidence Act explains that the oral evidence must be direct. Now, who are competent witnesses? What is competent witness? A witness who is of sound mind. He can tell the things which were happened in the past. Section 118 explains us about competent witnesses. Now, there are different types of the witnesses inside the courts of law. Some witnesses are dumb witnesses. Some witnesses are deaf witnesses. Dumb witnesses cannot speak properly. Deaf witnesses cannot hear properly. The concept of deaf and deaf witnesses is explained in section 119 in the Indian Evidence Act. Even though deaf witnesses and dumb witnesses, the evidence given by deaf witnesses and dumb witnesses is also accepted in courts of law. Section 119 explains that when any dumb witness gives the evidence by writing and properly signed by him, at that time that particular type of the evidence given by the dumb witness, it is a accepted evidence by the courts of law. Section 119. Now, how can a dumb witness or deaf witness give his evidence? That is a question. Now, dumb and deaf witnesses, they can give their evidence with the help of signs. They can give their evidence with the help of gesture, or deaf and dumb witnesses, they may give their evidence with the help of sign, gestures, or in handwriting. Dumb witnesses are also competent witnesses, section 119 of the Indian Evidence Act 1872. Now what is hostile witness? Hostile witness means a witness which is produced inside the court by the party, and that particular witness talks contradictory to the party who calls him. That particular witness is called as hostile witness. Section 154 of the Indian Evidence Act 1872 explains the concept of hostile witness. Now there is a question, बहुत बार लोग ऐसा सवाल पूछते हैं कि एखादी केस अगर जीतना है तो कितने नंबर, कितने विटनेसेस चाहिए, 2 विटनेस, 10 विटनेस, 4 विटनेस, 5 विटनेस. But the number of witness is no matter. Section 134 of Indian Evidence Act 1872 explains that number of witness is no matter. Only quality of the witness matters in court. Court never rely on quantity of witness. Court never rely on quantity of witness. Court must check the truthfulness and quality of witness. Section 134 explains that there is no limit of the number of witness, but court must check the quality of witness, not the quantity of witness. Now, what are privileged communications? There are different type of the communications that are taking place in between doctor and patient, that are taking place in between lawyer and his client. These type of the communications, they are called as privileged communications. There are different type of the communications. Some legal advice is taken by the client. Now, section 121 up to section 129 explains us about privileged communications. Now, what is privileged communication? Privileged communications are those communications which are protected by the courts of law. Courts of law cannot compel to open the secret communications in between patient and doctor, in between lawyer and his client, but the condition is that these communications must be real and these communications must be for legal purpose. Now, the communications with the judges and magistrate, they are explained in section 121 of the Indian Evidence Act 1872. Some communications, they are taking place during marriage in between husband and wife. Section 122 of the Indian Evidence Act explains the communications that are taking place in between husband and wife. Court of law cannot compel any husband and any wife to open the secret communications as per section 122, but these communications must be legal one. Now, what are professional communications? Section 126 of the Indian Evidence Act 1872 explains the professional communications. Court of law cannot compel to tell the professional communications in between lawyer and his client. Now, what are professional communications? Professional communications are the confidential communications taking place in between lawyer and client, but the communications must be legal. The professional communications may be in between doctor and his patient. Section 129 of the Indian Evidence Act explains the confidential communications of a client with his legal advisor. Court of law cannot compel any legal advisor to come in witness box and to tell the privileged communications to the court, but condition is that the privileged communications must be for legal purpose. Now, what is chief examination? What is re-examination? What is cross-examination? Now, what is order of examination of witness? विटनेस बॉक्स में जब विटनेस आता है तो पहले चीफ एग्जामिनेशन रहता है, बाद में क्रॉस एग्जामिनेशन रहता है, बाद में री एग्जामिनेशन रहता है। सेक्शन 138 of the Indian Evidence Act explains us order of examination of witness. Now, what is order of examination of witness? First, the party who produces his witness, they are checked by the lawyer of that party. It is called as chief examination. Section 137 explains about chief examination. Now, what is cross examination? Cross examination means the opposite party lawyer asks some questions when the witness is present inside the witness box. That is explained in section 137 of the Indian Evidence Act 1872. Now, what is re-examination? The party who called that witness, if there are some points which are remaining, then there is a provision in Indian Evidence Act 1872 of re-examination. Section 138 of the Indian Evidence Act explains us about order of examination of witnesses. Now, first is chief examination, second is cross examination, third one is re-examination. All is explained in section 137 of the Indian Evidence Act 1872. But one condition for PP and APP is that they will never ask leading questions. Leading questions may not be asked to a witness by PP and APP. Leading questions may not be asked to the accused by PP and APP. Leading questions may not be asked by PP and APP. Now, what are dying declarations? There is a concept in Indian Evidence Act 1872 of dying declaration. मृत्यु शैया पर जो आदमी होता है, ऐसा माना जाता है कि जो आदमी मरने को आया वाला है वो कभी झूठ नहीं बोलता. There may be some reasons or there may be some causes for the death of that person. The declarations made by a person who is on bed at the time of his death, these declarations, they are called as dying declarations. Dying declarations are accepted by the courts of law. Dying declaration. The provision of dying declaration is explained in section 32 and section 33 of the Indian Evidence Act 1872. Now, what is dying declaration? मृत्यु शैया पर एखादा व्यक्ति जब रहता है, ऐसा माना जाता है कि वो उसके कॉज ऑफ डेथ के बारे में कभी झूठ नहीं बोलेगा. तो सेक्शन 32 and 33 of the Indian Evidence Act gives the powers to the court to let us assume dying declarations. Now, law is very critical. It is not necessary to make conclusion on handwriting, to make conclusion on fingerprints, to make conclusion on medical witnesses. So, judges always require experts. Judges always require expert persons to tell their opinion about the facts. Section 45 explains us provision in Indian Evidence Act about expert opinion. Section 45 to section 51 explains us the different provisions which are given about opinion of third person when relevant in courts of law. Third person opinion. Experts are third persons. Judges are not very perfect in fingerprints or in mobile recording opinion. Judges are never perfect in fingerprints opinion. Judges will ask the opinion of a third person, that is called as expert opinion. This expert opinion is about any medical fact. This expert opinion is about fingerprints, or this expert opinion is about handwriting of a person. Section 47 of the Indian Evidence Act explains us opinion of a third expert person as to handwriting when relevant. Now, this Indian Evidence Act also gives a power to the witness to refresh the memory of the witness. Suppose witness is present inside the witness box and the case is in the trial stage. Trial stage came after 2 or 3 years. At the time witness, there may be a chance that the witness have forgotten all the things. So section 159 gives the power to the witness to refresh his memory. Witness, when present inside the witness box, may ask for the production of any document related to the case. Witness may ask for the production of any document which is related to the case, which is submitted inside the court, and witness may refresh his memory. This is a power given by the Indian Evidence Act as per section 159 of the Indian Evidence Act 1872. This is a very common law, and all the general public must know what are the different provisions in Indian Evidence Act 1872.